file it. What's date?
I'm sorry, we can do December 12th.
All right, Mr. Smith. Hello, how are you doing?
Good.
All right, we're gonna schedule an evaluation for you to make sure that everything is fine with you. So we're gonna bring you back on December 12th, but if everything is, I'm sorry,
I already
yes.
had an evaluation.
Oh, you've had a competency evaluation?
Yes, ma'am.
When did you have that?
About 2.5 weeks ago when I was upstairs on 5th floor.
Okay,
I'll look into that.
all right, Norma, let's do this. Give me a date for him in November, the second week in November.
Can I get a PR bond or something? And I already had an evaluation.
Hold on.
November 13th.
All right, so this is what will end up happening. If your attorney wants to file an application for a PR bond, he can file an application for a PR bond. I'm not your attorney. I'm not allowed to do that. So your attorney will have to file it. And if your attorney files it today, we will have it heard tomorrow. Do you understand?
So let me out putting off my court date until when?
November 13th.
There's nothing I can do to go home today. I mean, I already had an evaluation.
Okay. All right, Mr. Wolf, you want to speak to your client and see if he needs another evaluation?
I'll talk to him.
All right, thank you.
Will I be able to talk to, I know
Sure.
you have court going on.
Jeremy Garcia. All right, thank you. And probation, this is an application for deferred. Hello, good morning. I'm going to need you to make sure that you speak up because we have a lot of things going on here. Mr. Wolf, you're going to have to be moved down to the end. So if you'll wait to talk to your client once we're off the record, or if one of the attorneys finish speaking to their client, okay? All right, court is calling 2023 CR 7562, State of Texas versus Jeremy Ray Garcia. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Adam Coons for Mr. Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And
Yes.
did you sign it?
Yes, ma'am, I did.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am, we are, Judge.
We're on the record. All right. We are on the record. Counsel, I'm sorry, Mr. Garcia, showing you what's entitled court admonishments and defendants waivers and admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
All right, did you understand you're charged with theft of a firearm? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application of deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am. I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, state recommends deferred adjudication. They're taking in consideration 712-934, 716, 716. Did you understand that to be the plea?
Yes, ma'am. I did.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I have.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and no harmful or injurious contact with Alicia Gonzalez. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I do.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 and the attachments.
We reviewed them and have no objections, Your Honor.
All right. And with regards to the no harmful or injurious contact with Alicia Gonzalez, she's aware of what's happening and that is what she's requesting?
Well, ma'am, another prosecutor's spoken to her, and based on the notes in JD, that's it seems to be what she's requesting, Judge.
All right, thank you. You may be excused to continue to confer.
Thank you, Judge.
Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I have.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, please.
Anything you wish to say on behalf of your client?
Judge, obviously, we're requesting you file this plea bargain. He made a terrible mistake a couple of years ago when he needed some money. He was in a downtime in his life. He has several small children. And he's very apologetic and is very grateful for this opportunity. I've explained to him how important it is to successfully do everything on probation, and that if he does well, that there's a potential that his probation could be terminated early. He understands that. He is looking forward to getting back with his family. He has been in custody this current time for about 2 months already. So he's looking forward to getting back and going back to work and trying to help support them.
All right. Is there anything you want to say?
Just that I am grateful for this opportunity. I just really miss my kids. So
Well, you know, it's your fault.
yes, ma'am.
All right, this is what the court is going to do. 4 years deferred adjudication, no harmful or injurious contact with Alicia Gonzalez. Take in consideration County Court Cause number 712-934, 716-716. Are you currently employed?
Yes, ma'am.
Doing what?
We put in office supplies for Cox centers.
Okay. So nothing like before.
You're not going to gun shops or anything like that, are you?
Oh, no, I was installing security cameras at the time.
So I'm assuming nobody's using you to install security cameras anymore.
No, ma'am,
Okay.
unfortunately. No.
Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. Regular reporting by Zoom or in person. Regular UAs. Field visits. One time per month. For 3 months. Probation, if there are no issues, then you can discontinue field visits or as you deem them to be. There should be 80 hours of community service restitution. I'm gonna order parenting classes. Once you completed the parenting classes, then your community service hours will be deemed satisfied. Probation, is there anything else he needs?
No, Your Honor.
Is there anything else you need from me?
No, ma'am.
Nobody requested a theft course, so I'm going to give you your theft course. Don't take what doesn't belong to you. If you're taking something, you need to pay for it. Do you understand?
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record from here on out. You need to be trying to make your children proud of you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge. Thank you.
Thank you. Jose Ruiz, why do I keep getting this file back?
Oh, Lorraine actually had to run to the 186. I'll text her and let her know.
Okay. All right, we're done with that file. Kevin Correal.
Present.
All right. So today is discovery day on this case. Where are we on discovery?
I think we've received it, Your Honor,
Okay. And has an offer been tendered or no?
just as we speak, earlier this morning.
Okay.
And so we haven't had a chance to confer with my client regarding the offer.
All right, Ms. Ferguson, can you recall this for 30 days for a plea deadline date? All right, we'll come back on November 30th. At that time, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, thank you. Once you sign the reset form, you're excused.
Just have a seat.
Okay, but that one's done. Paris Ferris,
He's still downstairs, Your Honor.
they still have your client downstairs.
We're still waiting on a competency on this one, Judge.
Oh, you are?
I haven't received a report yet to see that they've completed their evaluation.
All right, let's do this. Let's make sure we get him out here so he can know what's going on, and then we'll get a date and everything.
Yes, ma'am.
Carlos De Leo. All righty. Where are we?
Trying to pick a side here.
Okay,
Morning.
good morning. Well, y'all have the brains of the operation behind you.
I know. she should
That's
be
what
up
I'm
there.
saying.
I'm over here on the side.
Okay. All right, so where are we on this?
The last hearing we had, we've gotten some results back from Houston Forensic Science Center, and we were requesting the underlying data to support those findings and conclusions. We've received that.
Okay,
I am in the process of giving that to my client and to our expert
Okay.
for analysis. Unfortunately for my purposes, my client is not able to look at anything digitally. And it's a whole bunch of stuff digitally. And so
Okay.
I've got to print that all out, get it over to my client and to our experts. And they
he
can-
can't listen, he can't look at anything digitally? Ah, okay,
No PDFs. Yeah.
all righty.
So that's where we are, and we're in the process of trying to get all that done. And I'm hoping that once we get that analysis looked at and done, we can get an expert opinion back on that and be able to proceed and go forward.
All right, how long are you all anticipating this? Because this is one where there is a conviction and we're just trying to see if that conviction is a
Right,
proper one.
right.
So,
Matt and I were talking today, and we're thinking at least 90 days, maybe even 120, get us through maybe February before we're gonna be able to have an expert review. It's a ton of stuff, Judge.
Okay.
It's just a ton of stuff. And so we've got to figure out, it just.
And your client is not in prison.
He is in prison. On this one, he's in prison. The other one, he's not. He's actually out on parole.
All right. So which prison is he located at? So would it be easier to have him bench warranted back here? I know there's an issue with the time. Would that make things run smoother?
No, not really. I mean,
Okay.
because really what we're looking for is our expert analysis on the underlying data and the results that were obtained from.
Well, I mean, I know because you said he needed to review things. I'm wondering if that would make it easier. If not, then it won't.
Knowing my client, he wants it. He wants the actual results.
No, I mean, bring him here
Right.
and he can look at whatever you wanted him to look at. But if you all don't think that will make things run any quicker, that's fine.
It's not, Judge. I
All right.
appreciate that, though.
Sure. Ms. Ferguson, they're asking for 120 days. Normally that's never done, but okay.
It's just that we're not wasting the court's time coming back. And
It is never a waste.
we're still working on it.
Okay.
And Judge, so the court's aware, the state is prepared to, I mean, the final piece of the puzzle here is that 6404 hearing.
Mhm.
We're prepared to move forward on that, but I mean, the big issue here is that Mr. De La O has to carry his burden. We want to be able to, we want to give him as much time as possible, give Mr. McLean as much time as possible to review
Okay.
documentation here, basically be ready to have that final hearing. So really the last statutory requirement on the court is that 6404
Yes.
hearing.
And no, we'll have it. And I want to make sure that everybody has everything that they need to go forward.
Appreciate that.
February 22nd.
All right, we're going to come back on February 22nd, 2024. Time has gone by quickly.
It has. All right, we will do our level best to be ready on that day, Judge.
All right, thank you. You're welcome.
See you then.
Nicholas Ramos.
Minutes.
All right. So how many cases are we proceeding on? Just one, okay. All right, court is calling 2023 CR 3133B, State of Texas versus Nicholas Ray Ramos. Can I have parties announced for the record for the state?
Daniel S. Clark for the state of Texas.
On that side.
Anthony Cantrell for the defendant.
And are you Nicholas Ray Ramos?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged by indictment with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Okay, according to the plea, punishment is to be assessed at a cap of 16 years in the prison. There are no applications. This will run concurrent with County Court Cause number 6915448, 6915449, 694250, and there will be several cases taken in consideration. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Good.
State any evidence?
State offer states exhibit 1 and all attachments. No objection.
All right, you may continue. First, showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. This will be set for sentencing on December 7th. We'll schedule PSI. And even though he's not applying for probation, I am going to schedule a TAP evaluation that'll give me some idea.
Thank you.
Is there anything else, counsel?
No, Your Honor.
All right. We're going to come back on December 7th. I'll make a decision on your sentence based upon any other evidence that's presented to me in the TAP evaluation in the PSI. Do you understand?
Yes, ma'am.
All right, thank you. And the state tendered some dismissals, so I will give those to you.
Ready.
You're welcome.
We'll do this over there. Sure. Good idea. We'll see you soon. Set up a visit.
All right, let's talk about that. Jeremy Ray Garcia and Nicholas Ray Ramos both entered pleas in judge's courtroom, but their outcomes looked very different. One walking out with probation, the other staring down a long prison cap charged with theft of a firearm, took a deferred adjudication deal. The judge walked him carefully through the paperwork. He understood the state jail felony carried up to 2 years. He waived his jury trial rights, and he pled no contest. The state recommended 4 years deferred, plus no harmful contact with Alicia Gonzalez, a TAP evaluation, community service, parenting classes, and proof of employment. Garcia's attorney leaned into his client's remorse, stressing that he had several small children, had already spent 2 months in custody, and was eager to get back to work. Garcia himself just said he was grateful for the chance. The judge reminded him bluntly that it was his own actions that brought him here, then gave the deferred probation with conditions and a sharp reminder: don't take what doesn't belong to you. It was tough love, an opportunity, but with plenty of strings attached. Ramos's case, by contrast, was far heavier. Indicted for aggravated robbery, a first-degree felony carrying 5 to 99 years, he pled guilty under a deal-capping punishment at 16 years, with several other cases taken into consideration. He, too, waived his rights and admitted guilt, with the judge noting the plea didn't guarantee probation and that sentencing would follow a PSI and TAP evaluation. Unlike Garcia, Ramos wasn't angling for probation. The cap was the win, cutting off the possibility of a life sentence. His sentencing was set for December, with the judge making clear she'd weigh all reports before deciding where within that 16-year ceiling to land. The overall atmosphere was formal and steady, with Garcia's hearing carrying a note of hope, early termination possible if he complied, while Ramos's was more sobering, the focus on limiting exposure rather than avoiding prison altogether. Time to break this one down. Judge handled both with her trademark mix of clarity and candor: probation for the man who still had a chance to prove himself, and a sentencing cap for the man whose crime was far too serious for leniency. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.